Guys, myself Solat Hassan, and I welcome you again to our last module, that is module 6, and in fact the last segment of our entire session. This module 6 is about, this is not module 4 guys, this is the last module 6. Okay, module 6. I had written it module 4, that was already written before. Okay guys, in this module we'll be doing nothing special as such. It's all the conclusion. We have taken out the conclusion from all above 5 modules, the previous 5 modules which we have discussed. This is nothing but the important relevant case laws on the topics which we have covered in the previous modules, and of course, after those case laws, we will be summarizing the entire session, what things we have covered till now in all the above 5 modules. So guys, let's begin and start with the case laws analysis. We'll just go through the brief facts. That is not analysis actually, because that would I have taken here 10 case laws, and that would stretch. If it would have been an analysis, this would have stretched the entire module again so long. So just case laws to show the relevancy of those topics and the legal stand on those points. Okay, the first case here we are going to discuss is Balfour versus Balfour. The cases which I have taken, guys, that is all the cases are a landmark judgment and a famous and landmark established principle at their own. So even the Balfour versus Balfour is a very important case. You would find the reference of this case in most of the places. So this is a case, this is an old case, a case of year 1919, an English case of 1919. Guys, we will be taking English cases as well as Indian cases, because what matters is to understand the legal principles being taken by the court, legal stand being taken by the court. So Balfour versus Balfour, this case, before starting this case, let me tell you one thing, that when we were discussing our first module, the very first module, when we have discussed the basics about the Indian Contract Act, of course the fundamental of the basics of the contract, we discussed one thing about the social agreement, about the domestic agreement, about the religious agreement, and of course about the commercial agreement. So what we have seen, only the one category, that is commercial agreement, was enforceable before court of law, and not the other ones, whether it be a social agreement or a religious agreement or a domestic agreement. None of those were allowed to be enforced. And why? Obviously, because there was no intention of the parties to create a legal relationship. So somewhat the same thing, same underlying principle you would find in the facts of this case, Balfour versus Balfour. So let's have a look. Now here one Mr. Balfour is there, one Mr. Balfour, and the other one is Mrs. Balfour. Okay, this would be very clear from this picture that these both Balfour, Mr. Balfour and Mrs. Balfour, are of course the husband and wife. Mr. Balfour, and there is a suit, this is the suit between this husband and wife only and none other. Okay, Mr. Balfour is a civil engineer in Ceylon. Okay guys, the places or the profession of the parties are not that important, but since we are dealing with the facts of the case, so the profession, this is a case somewhat related to the maintenance claim, and in maintenance claims the profession of the husband or the financial status of the husband is quite relevant. So it's being discussed here, even though this was not of legal implication. The agreement entered between them was declared by court of not any legal implication, but still, the facts are important. So this Mr. Balfour is a civil engineer in a Ceylon. Ceylon is what? Yes, of course, you might be knowing Ceylon is an old name of presently known Sri Lanka. Okay, so this is an old case, so we are using the term Ceylon in place of Sri Lanka. Now, Mr. Balfour, since he was a civil engineer, he lived in Ceylon. Obviously, he was living with his wife also, so she is also a resident of Ceylon. Now, what happened? These two, husband and wife, went to England on a vacation. You know, they both went where? They both went to England. Okay, England for vacation. England for what? Not to leave or they have shifted, but just for vacation. Now what happens when they have moved to England for vacation, and after they were done with their vacations, Mr. Balfour and Mrs. Balfour were about to return back to their home country, that is Ceylon. Mrs. Balfour fell ill. And due to health reasons, doctors of England suggested her to stay for few more days in England because of health reasons, and they thought that the weather of Ceylon was not suitable, might not suit to Mrs. Balfour, so it's better for health reasons Mrs. Balfour to stay for some more days in England. Now, this at the advice of doctor, what Mr. Balfour said, just orally agreed that okay, Mrs. Balfour, he said to his wife that you stay in England and I will pay you what? He agreed to pay 30 pounds, okay, 30 pounds to Mrs. Balfour till she came back to Ceylon. So to live there in England, he agreed her not 3 pounds, actually 30 pounds to Mrs. Balfour, to his wife, until she comes back to Ceylon. And in fact, Mr. Balfour was paying that amount until the difference arose between these two, husband and wife. And you know, differences are very obvious between husband and wife. At times they are like very trivial and very small differences, but at times it takes a big shape and causes a differences and they drag each other to court. So here also it became a big difference, and they both came back to court since Mr. Balfour, after that difference, stopped paying that maintenance amount to Mrs. Balfour, and Mrs. Balfour now sued Mr. Balfour for those 30 pounds payment. Now what court said here, the claim of Mrs. Balfour was dismissed by the court. Why? Because court said, look, the agreement or the condition, the promise made by Mr. Balfour to pay you 30 pounds was not intended to have a legal relationship. That was not that was just mere a social agreement, and social agreement are not allowed by the court to be brought before court of law. So here this agreement was declared to be mere social agreement, and court rejected the plea of Mrs. Balfour. So this is all about the case of Mr. and Mrs. Balfour, that is Balfour and Balfour, and a very relevant case from the point of view which we have discussed, and a landmark judgment. Now the next case, next case is also very important. So our second case of our this module is IALM Shukla versus Gauri Dutt. Okay guys, the second case is, this is also a very interesting case. You know, all the cases, personally I find the facts and the heads of a case very interesting. I enjoy reading, case laws. The next case what I am going to talk about is IALM Shukla versus Gauri Dutt. Now this is a case between a master and his servant. Master and his servant. Now servant is one who files a suit, and obviously if servant is one who files suit, who will be the servant here? Obviously this IALM Shukla, because the one who files the suit, he comes before, and the later who defends the suit is at the last portion, after this verse. Lalman Shukla is your servant and Gauri Dutt is what? Gauri Dutt is the master. Okay. And then what happens in this case? One, Lalman Shukla is the servant and Gauri Dutt is the master. Here, the nephew of Gauri Dutt, one nephew of Gauri Dutt did not come back to home, and he was lost, in fact, to which Lalman Shukla, the servant, went to find him. When Lalman Shukla, the servant, went to find that already has left home to find the nephew of Gauri Dutt later on made an announcement that whoever will bring back the nephew of Gauri Dutt, he is going to reward that person, okay? Reward that person with certain amount. Now, accordingly, Lalman Shukla, who has left the place to find the nephew, he found him and he brought him back. So where were we, guys? This Lalman Shukla, who is the servant here, he brings back the nephew of Gauri Dutt, and then he got to know from the other servants that, look, master has announced a reward of rupees, what? 501. It may sound to be, very meager amount, but actually this is also a very old case of 1913. Look, so in this period there was some value of rupees 500 even. So he Gauri Dutt announced a reward of rupees 501. Now Lalman Shukla thought, he said that, look, I have completed the deal, I deserve the reward. So he asked Gauri Dutt for rupees 501. Now Gauri Dutt refused that amount. He said, I didn't offer you this when you were here. Now Lalman Shukla is very angry. He goes to court and file a suit against his master to recover that rupees 501, that reward amount. Now what court says? Court rejected the claim of Lalman Shukla. What the court said? That the offer was not made to you, that was involuntarily act, a gratuitous act you did out of some other capacity, obviously because of you had a master servant relationship, you might have done it because of that, but not you cannot make your claim as per the offer and acceptance rule, because the law clearly says that there can be no acceptance unless there is an offer addressed to that person. It's not a general offer. Even a general offer must be when they are performed, they are communicated, they are in the knowledge of the person accepting it. They accept it. They are just not required to communicate their acceptance, but they accept it by their conduct. But here in this case, what Lalman Shukla did, was in ignorance of that offer. There can be no acceptance unless there is no offer. So here the principle which we have studied while we were dealing with valid acceptance and offer in our module 3, of course, which was you can't forget this module. That was a pretty long module, and in that, while we are dealing with the essentials of valid offer, we discussed that there can be no acceptance unless and until there is no offer. So guys, this was all about Lalman Shukla versus Gauri Dutt case. That is also an old case, that is 1930.